Good afternoon, Dr. Emanuel. This is going to be our supplementary question and answer session on the Supreme Court ruling on the Affordable Care Act, which took place yesterday, June 28th. As you know, there's been a great deal of discussion both in the media and among our students surrounding the decision, so let's elucidate a few things for our class. The first thing our students want to know, obviously, is what the political implications of the ruling are going to be. So, for example,
before we get to the political implications, let's talk about what the ruling actually was. The challenge by the attorney generals was that the mandate, the requirement that individuals buy health insurance in the law is unconstitutional and it violates the Commerce Clause. The main argument is that people who don't buy health insurance are not engaging in commerce. And so you can't apply the Commerce Clause to them. The government said, oh, yes, they are engaging in commerce because, for one thing, they might use health insurance, or they might use health care, and in which case not having health insurance externalizes that cost and places some cost shifts to everyone else. And not engaging in the market also affects premiums of everyone in the market. Part of the argument adhered on the fact that the healthcare is not your usual market, not like the market, as it were, for broccoli. The justices, 5 justices said, you know what, the Commerce Clause doesn't apply. It really, Congress couldn't, under the Commerce Clause, actually require people to have insurance or pay a penalty. That seemed a little unusual to many people. If you read a lot of Justice Scalia's decisions, he has a very expansive view of the Commerce Clause, so this was unusual. But the Chief Justice said, well, it's a tax. And under the taxing authority, Congress can tax people for not doing something like not buying insurance, and therefore we can assume, or we can say that the law is constitutional. So that was the basis of the ruling. There's also this Medicaid issue, and on the Medicaid side, the bill says we're going to expand Medicaid, and now states you have to cover everybody who's under 133% of poverty. And by the way, the federal government will pick up for the first 3 years 100% of those costs, going down to 90% of those costs. 7 of the justices, the 5 conservatives and Justices Breyer and Kagan, said, yes, this Medicaid is not just an expansion of an existing program, it's really a new program with using the old name, and you cannot penalize states by taking away their old Medicaid money if they don't expand Medicaid. And they said that that was overreach. It was really coercive on the states, and therefore states don't have to expand or won't lose their old Medicaid money if they don't expand their Medicaid program in this new way. So that's the basis of the decision.
Fantastic. Thank you for all the clarifications. I think one of the follow-up questions our students will ask is, what does the reframing of the mandate as a tax by the court mean for both sort of the Democratic Party line and for the next possible Republican Senate? So if there is one, does that mean they can just eliminate that part of the legislation because it's now simply a tax?
So the first thing is that from a substance standpoint, it doesn't do anything. You're still paying the same penalty. You're paying it in the same way to the IRS. From a political rhetoric standpoint, Republicans may try to make hay out of the notion that this is a tax and President Obama is imposing a tax. The fact of the matter is that this penalty was only estimated to raise about $4 billion, I believe, over 10 years. Not a real lot of money, and certainly not the core money to pay for the healthcare reform. Second, it was always spending, and so it had a revenue part and an expenditure part, and therefore it could be changed by reconciliation. But you have to remember, if President Obama gets elected, he could veto any change. So the Republicans getting the Senate and passing a repeal of this would probably be vetoed if President Obama is reelected. If he's not, there are many other things the Republican Party can do in implementation in the executive branch that would gum up the works anyway.
Sure, absolutely. Now, since you're talking about the re-election and President Obama in general, can you tell our students a little bit about what a decision against the mandate would have meant for the current administration?
I think it would have been disastrous for the president if the Supreme Court had said that this legislation was unconstitutional. It would have meant that he spent a significant portion of his political capital on something that was unconstitutional. It would have meant that the bill, his signature bill, would have been weakened. It wouldn't have gone away. Probably 90% of it would have remained intact, but it certainly would have been weakened. And I think it would have been much more disastrous politically than actually practically. But disastrous politically, it certainly could have been.
Indeed, it could have. Now, in terms of sort of keeping the mandate on as a tax, we've already talked about what this implies for the policy as a whole. What do you think it means for the interpretation by the courts of congressional power going forward, and where those boundaries lie?
Well, that's interesting, but I'm not a constitutional lawyer. It clearly is meant to hem in the Congress and limit its power under the Commerce Clause, and also limit how it can, what it can require the states to do under these grants. For many, many years, the federal government could not tell states what to do, but what it could do is sweeten the pot and say, we'll give you this money if you do the following. So, for example, the way the drinking age became uniform across the country, even though it's state-based, is that the federal government said, oh, we're going to tie your receipt of federal highway funds to raising the drinking age. And all the states felt like they had to do that. This ruling may limit the ability with which the federal government can do that. It certainly says you can't really radically change a program and then claim it's the same program, and that you're going to threaten all the money of that program.
Absolutely. Thank you. Well, thank you actually very much for coming out here today.
Good.
And this is going up for our students to see.
I hope this is helpful, and we look forward to students sitting through the rest of the course and learning a lot more about the Affordable Care Act.